An emergency guardianship is a determination by a court that someone does not have legal capacity. In Texas, every adult, every person over the age of 18 is determined to have legal capacity to make legal decisions, medical decisions, financial decisions for themselves. And so it's presumed that you have that capacity to do so, but sometimes you may have been in an accident, maybe you have a medical situation like a stroke, you're in a coma, now you're not awake, or you may have a situation where your mental ability is compromised and you can't make competent decisions for yourself. In those situations, a guardian must be appointed for you to make those important medical and legal financial decisions unless you have given authority to someone under a power of attorney to allow them to make those decisions for you. If you don't have powers of attorney in place for medical decision-making, legal and financial decision-making, and something happens to you where you lose your mental capacity, then an emergency guardianship must be filed to allow someone else to be given legal authority to make decisions for you. That can be a really stressful experience because you're not in a good place and your family has to go to court and spend a lot of money to ask a judge to give them authority to make decisions for you. This can so easily be avoided by proper estate planning. If you have a medical power of attorney that names someone else to make medical decisions for you when you are incapacitated, a guardianship is not necessary for medical decision-making. The same is true for legal and financial decisions. Again, you want to have a legal and financial power of attorney, sometimes called a statutory durable power of attorney, in place, naming someone else to make those decisions for you in the event you become incapacitated. If you have those documents in place, an emergency guardianship will not be necessary. You'll save your family a lot of stress and heartache and save a lot of money in the process. If it's necessary to file an emergency guardianship, your family will have to file in court an application for guardianship. They often will have to have an affidavit from a doctor that says you have been injured or that you lack mental capacity to make your decisions. Several people will have to be served with that document. Everyone in your family that would have an interest in your well-being, such as your parents, your siblings, sometimes your children, depending on the situation, everyone has to be served. And sometimes those people may not agree to the person who's applying to be the guardian. So now you've got people fighting over who should be your guardian, who should make the decisions. That extends the process, makes it more difficult, and a judge has to decide, first of all, is a guardianship warranted? Is it necessary? And secondly, who should be the guardian? If people are fighting over that decision, that makes that process a lot more difficult. If an emergency guardianship becomes necessary, that process can be done fairly quickly. The application for emergency guardianship is filed. The court will review the affidavit and often will enter an order of emergency guardianship based on affidavits only. Within a short period of time, the court is going to want to have a full hearing to gather more information and to make clear whether you are still in need of an emergency guardianship. Sometimes this is only for a short period of time. If you are in an accident and maybe you are in a coma for a couple of weeks, that temporary guardianship is all that is necessary. However, if that medical situation is going to continue over an extended period of time, your family will have to turn that temporary emergency guardianship into perhaps a permanent guardianship. Again, more experts will be necessary, medical experts, to determine your incapacity, to determine how long that incapacity may last. And again, if your family is fighting over who should be the guardian, that may continue from the temporary guardianship proceeding into the permanent guardianship proceeding. A permanent guardianship proceeding will last as long as you are incapacitated. That could be years. And if that's the case, whoever is appointed to be your permanent guardian will have to report to the court on an annual basis as to your physical well-being. They'll also have to report to the court as to the status of your financial situation. So a court is going to be involved in overseeing your guardian's care for you for the duration of the guardianship. So this means that whoever's your guardian is going to have to, on an annual basis, provide an accounting of your financial situation and provide the court information about your physical well-being. If you have questions about guardianship and how to avoid it, please give us a call at DeFord Law Firm.